You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. I'm your host, Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is why some patents are published and others are kept secret. So let me start with a question that comes up way more often than you'd think. Someone files a patent application, and then a year and a half later, they Google their invention, and boom, there it is, published online for the whole world to see. And they panic. They say, wait, I thought this was confidential. Why is this public? And someone else files a patent, and years go by, and nothing ever shows up. No publication, no public record, totally invisible. So what's going on? Is this random? Is the patent office flipping a coin? Or is there actually a method to this madness? The short answer is there's a rule, and then there's an exception to the rule. And if you don't know about the exception ahead of time, it can really surprise you. So here's the baseline. In the United States, most patent applications are published automatically about 18 months after the earliest filing date. Not after you file, but after the earliest priority date, which can often be a provisional application filed earlier. That 18-month mark is pretty strict. The USPTO doesn't ask if you're ready, doesn't check if your product is launched, it just publishes it. The idea behind this is transparency. The patent system is a bargain. You disclose how your invention works, and in exchange, you get a limited monopoly. Some people don't like to call it monopoly, but it's a form of monopoly, even if that's not technically the right term. Publication is part of holding up your end of that deal. Now, a lot of inventors assume publication only happens if the patent is allowed. That's not true. It is true for design patents, but it's not true for utility patents. Publication happens whether the patent ends up issuing or not. Even if the application is later rejected and abandoned, the publication still exists. The disclosure is out there forever. That's why filing a patent application is not something you want to do casually or half-baked. Once it publishes, there's no undo button. So, then why are some applications never published? That's where the exception comes in. If you file a U.S. patent application and you certify that you will not file any foreign patent applications on that invention, you can request non-publication. If the USPTO accepts that request, your application stays secret until a patent actually issues. That surprises people. They assume the patent office wants everything public. But the logic here is practical. If you're only filing in the US and you never plan to go international, there's less policy pressure to publish your application early. So the system gives you that option, but it comes with strings attached. The biggest string is, if you ever decide to file internationally, you must notify the patent office and withdraw the non-publication request. And you have a deadline to do that. If you miss it, your US application can be abandoned. Just like that, no grace period, no oops, my bad. This is one of those rules that patent attorneys lose sleep over because it's an easy mistake to make if you're not paying attention. Now let's talk about why someone would want non-publication in the first place. The main reason is secrecy. Maybe your invention is something that can be reverse engineered easily once it's public. Maybe you're not sure if you want to patent at all and you want to keep your options open. Or maybe your invention is closely tied to trade secret strategy. In those cases, keeping the application unpublished gives you more control. If the patent never issues, the public never sees the disclosure. But there's a trade-off. When your application is published, you may be able to collect damages for infringement that happens after publication, assuming certain conditions are met. That's called provisional rights. If your application never publishes, you give that up, so secrecy comes at a cost. Another thing people don't realize is that even if your application is unpublished, it's still examined. Examiners still search it. Office actions still happen. The process looks the same on the inside. The difference is just whether the public can see it. And here's another wrinkle. If your patent issues, publication happens automatically at issuance anyway. So non-publication doesn't mean the invention stays secret forever. It just means it stays secret until you actually get a patent. At that point, disclosure is mandatory. Now, sometimes inventors assume they can just decide later whether to keep things secret. But in reality, the decision has to be made early. It's usually made at filing, and it should be made strategically, not emotionally. This is where you want to think about your business plan, your competitors, and whether foreign protection might matter later. So when you see a patent that never had a published application, it doesn't mean something shady happened. It usually means the applicant made a conscious choice to keep it non-published, and they stuck to that choice. Or they only ever cared about U.S. rights. And when you see your own application suddenly appear online, that doesn't mean you messed up. It usually just means the clock hit 18 months and the system did what it always does. Understanding this distinction can save you a lot of stress and in some cases a lot of money, because once publication happens, the genie's out of the bottle. So now that you know that there's a choice involved, the real question becomes, how do you decide which path makes sense for you? This is where inventors sometimes get tripped up, because it's not just a legal decision, it's a business decision. And honestly, it's one of those moments where you want to zoom out and think beyond just, do I want people to see my idea or not? Let's start with the benefits of publication, because it's not all downside. When your patent application publishes, it creates public notice. That means competitors can see you're staking a claim in a particular space. And sometimes that alone has value. It can scare people off. It can signal that you're serious. It can even help with fundraising, because investors like seeing that you've taken formal steps to protect your technology. There's also that idea of provisional rights I mentioned earlier. If your application publishes and later issues as a patent, you may be able to recover damages from infringers going back to the publication date, not just the issue date. That's not automatic and there are hoops to jump through, but it's something you give up entirely if you choose non-publication. So if you think infringement is likely early on, publication can actually help you. On the flip side, secrecy can be powerful. If your invention is something that competitors could copy easily just by reading your application, keeping it unpublished can buy you some time. Maybe you want to see if the market even cares. Maybe you're not sure the patent will issue and you don't want to give away the details for free. In those cases, non-publication acts like a safety net. If you abandon the application, the public never knows what was inside. This is especially relevant for startups that pivot a lot. You might file a patent application early, then realize 6 months later that the product is going in a totally different direction. If that application publishes, your early idea becomes public knowledge forever, even if you never commercialize it. For some companies, that's fine. For others, it's a big problem. Now let's briefly talk about trade secrets, because this is where publication decisions often intersect. A patent and a trade secret are opposite strategies. A patent requires disclosure. A trade secret relies on secrecy. If something is core to your business and can't be easily reverse engineered, sometimes trade secret protection makes more sense than a patent. But once you file a patent application and it publishes, that option's gone. You can't undisclose anything. That's why sometimes you see companies file patent applications on some aspects of their technology while keeping other aspects secret. The publication decision becomes part of a broader IP strategy, not just a checkbox on a form. And here's another subtle point. Even if you request non-publication, you're locking yourself into a US-only strategy unless you actively undo that request later. If there's any chance you might want foreign patents, you need to have a plan for that. I've seen inventors say, we'll never file internationally, and then a year later, a big foreign distributor shows interest. Suddenly, international protection matters, and now the timing becomes critical. If you miss the deadline to notify the patent office that you're filing abroad, your application can be abandoned automatically. That's not a scare tactic, that's just how the rule works. So if there's uncertainty, publication may actually be the safer path. One more thing worth mentioning is that provisional applications don't publish on their own. They only become public if they're relied on by a later non-provisional application that publishes. So some inventors feel a false sense of security early on, thinking everything is still secret, without realizing there's a ticking clock once the non-provisional is filed. So when someone asks, why did my patent application publish? How did that one stay secret? The answer almost always comes down to strategy and timing, not luck. The system is predictable, but only if you know the rules going on. The big takeaway here is this. Patent publication isn't good or bad by default. It's a tool. And like any tool, it works best when you use it intentionally. If you understand when publication happens, when it can be avoided, and what you give up either way, you're in a much better position to make smart decisions for your invention and your business. And if you're not sure which path makes sense, that's normal. These decisions are nuanced, and they depend on things like your market, your competitors, your long-term plans. That's exactly the conversation worth having early before the clock starts running and options disappear. One thing we haven't talked about yet is early publication, because yes, that's also an option. You don't always have to wait 18 months. An applicant can actually request that the patent application be published earlier than the normal timeline. Why would anyone do that? Usually it's about business leverage. Early publication can put competitors on notice sooner, which can matter if you're entering a crowded space or talking to investors who want to see something public. It can also start the clock earlier for provisional rights, meaning if the patent eventually issues, you may be able to seek damages for infringement that happens after the early publication date. In other words, early publication trades secrecy for signaling and potential enforcement benefits. It's not common for every inventor, but in the right situations, it can be very intentional and very useful. That's it for today's episode. And if you need help filing a patent application or other intellectual property, give me a call at 424-281-0162. I'm Adam Diament, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.